An employer who fires an individual merely for being gay or transgender defies the law. We're coming up on the one-year anniversary of the Supreme Court's decision last summer regarding the extension of protections on the basis of sexual orientation and transgender status for the LGBTQ plus community. What that means for employers is up next on Employment Law After Hours.
The rights afforded to the LGBTQ plus community is the subject of this week's episode of Employment Law After Hours. We're going to dive deep into the decision titled Bostock v. Clayton County that was issued last summer by the Supreme Court. Again, that decision afforded the rights to the LGBTQ plus community to, be safe in the workplace and prevent them from being discriminated against or harassed solely because of their gay or transgender status. We got to say we're attorneys, but we're not yet your attorneys. Therefore, take everything we say in this video for informational purposes only and see the full disclaimer below in the description.
Right. So prior to that decision being rendered last summer, there were a lot of things that an employer could lawfully terminate their employee for just based on sexual orientation, transgender status, transitioning status.
Sure.
So now we see that those rights have been expanded and added to Title VII of the Civil Rights Act, right, Brian?
Yeah, so essentially prior to last summer's decision, at the federal level, employers could terminate employees solely for being gay or being transgender or transitioning. They didn't have any protections at the federal level. Now again, Title VII states that employers cannot discriminate against employees solely on the basis of sex, among other characteristics. The Supreme Court last summer said, hey, gay and transgender status fall under the definition of sex. Previously, that had been disputed at the circuit court and district court levels, but for the first time, the Supreme Court says, no, we're going to interpret sex under Title VII to mean also gay and transgender, as well as, of course, the traditional definitions of male and female as has existed since the 60s.
And this is actually an incredibly monumental decision because it took a number of years for the Supreme Court to even want to take this issue on.
Sure.
This has been petitioned for cert before the Supreme Court a number of times, and it wasn't until, as Brian said, there were all of these conflicting opinions coming out of our circuit courts. Specifically, in this case, there were three that all got sort of looped together in this one massive case concerning both sexual orientation and transitioning status. But really, it was pretty incredible to see the Supreme Court actually move on this issue.
Now, I think it's important that we jump into what are the states doing now. So obviously, at the federal level, employers can't discriminate based on, transgender or your gay status, which we interpret to mean sexual orientation, gender identity, and gender expression. But at the state level, there are a number of states where discrimination based on sexual orientation or transgender status is still permitted. I want to put those states on the screen. So they're definitely in the old times. They haven't updated their case law or passed any sort of statutes to afford protections to the LGBTQ plus community. However, despite the fact that at the state level they can technically be discriminated against, any individual who has a gay or transgender status could bring a lawsuit in federal court under the federal law.
That sort of distinguishes between the federal and the state court systems as to where one of these members of the community who may be affected by discrimination in the workplace on the basis of a sexual orientation or transgender status has the ability to bring a claim.
Monica, I actually have some pretty interesting facts here that I want to go through that discuss the intersection between the state and federal, courts in terms of these protections. So cool. 50% of the LGBTQ plus community actually live in states that prohibit employment discrimination at the state level. So that's great news for 50% of that community. 25% of the LGBTQ plus community actually live in states that explicitly interpret sexual orientation under the definition of sex, but they do not go as far as to including the transgender. So at least 75% of the United States LGBTQ plus community live in states where sexual orientation is protected at the state level. 23% of the LGBTQ plus community, which again are all in the states that we put on the screen, do not live in states that prohibit discrimination based on sexual orientation or transgender status, which, again, at this point I interpret it to be pretty meaningless that those states haven't implemented those protections, just because if an employee is part of the LGBTQ plus community and is discriminated against, then they can go ahead and file that lawsuit in federal court. They don't need to run to state court just because they live in that state. They can file that lawsuit after speaking with their attorney in that federal court.
What do employers within those states need to be doing to make sure that they are protected?
Absolutely. Great question. So not only for the employers in those states, but for the employers across the country, you need to be updating your employee handbook to ensure that your EEOC statement, your equal opportunity statement, states that you also prohibit discrimination based on sexual orientation, gender identity, and gender expression.
Right.
Take this as an opportunity to re-educate your workforce about harassment and discrimination, and ensure that they all know that, hey, these new classes are now included and protected from harassment and discrimination. So you can provide the education to those employees to make sure that they're paying attention in the workforce, they're looking out for their fellow coworkers, part of this community, to ensure that they're not being harassed or discriminated against.
And you should also make note that harassment policies extend beyond just things that on their surface appear to be harassment. So it's important that employees know and understand that even maybe quippy one-off remarks or jokes, comments, whatnot, that can be perceived as hurtful or offensive or discriminatory count as harassment. So, I know in a lot of workplaces there's banter among employees, and sometimes that extends into things that may be funny to some but not funny to others. Sure. It's important that when you're updating those policies, that's a part of those as well.
We should take this as an opportunity for employers to realize that, hey, once they become aware of harassment that's occurring in the workplace, they need to take action to stop and prevent it. Otherwise, you're just shifting that liability right to you, and again, in either state or federal court, depending on your state. But just because you're in a state that doesn't explicitly protect the LGBTQ plus community, they could still haul you into federal court, which I promise will not be an enjoyable experience.
Right.
So that's all we have for you today on Employment Law After Hours. Again, this decision coming at the end of Pride Month, we really wanted to do this episode, but this decision truly shows that employment law changes every day. There's new standards, new regulations coming out all the time. So make sure you hit that subscribe button. That way you're the first to know of any new changes that come about. We'll see you next time.
See ya.